For quashing the proceeding under section 138 NI Act.
Yes.
My lord, may I mention?
Give all the memos, we'll see. All the memos.
My lord, in spite of
Give the
direction,
memos.
my lord, matter was not listed. That is the only concern. It was directed to be listed.
Bharatpur police station case, CRLMC application that was filed.
What is the urgency now?
My lord, sir, we had filed one IA for the SIM cards to be handed over to the army officers. Let's see, till date, they haven't given us anything.
Who was appearing?
It was lastly listed on
Monday. Give the application. Have you moved some application?
Well, yes, my lords, I filed an IA for that. So that
We'll
is
see.
pending. So all those three matters have been tagged together to the CRLMC. So that is
We'll see.
much obliged.
2012 directed to be listed on 6th of April. And inadvertently it has been uploaded in on 10th. Can it be taken on 5th April? 2012 vigilance test.
What is the date now?
Now it is on in 10th April.
10th. 5th and 10th only 5 days. You waited till 2012.
It is the Saturday. No. It is the Saturday. You're not that.
Oh, so Saturday you want to do?
Yes.
Saturday if you want to do, but you have already, if there is a date is uploaded, then you have to move application. I
No.
can't recall like that.
Not yet.
My lord, may I mention?
Not yet uploaded.
My lord,
Oh.
the matter was directed to be listed on 12th March.
Because 5th is a Saturday. If
Saturday.
somebody wants to do it, we'll do it. Okay.
My lord, matter was directed to be listed on 12th March,
205 rejected, my lord.
but it has been deleted.
205 rejected. What is too urgent?
Health concern declared day by day.
What is the date there in trial court?
Trial court, my lord, that exact and marks code it.
Trial, just see if the next date of hearing is approaching, I'll take it up. And tell me that.
Yeah. And another, my lord. PMP, my lord. In spite of distant order, they are comfortable. How to hold my land?
Go to the injunction court.
Oh, that is their, my lord. Against that order, they have taken stay, my lord. I have filed a petition for vacation of stay, my lord. CMP. State matter against CMP is trusted. Obliged.
Legal office was mentioned by information. That matter was listed before the assignment student.
Huh?
That was listed before the assignment student.
Today?
Someone was mentioned
Assignment.
listed today before the assignment. Listed. So 2010 matter.
Okay. I thought that's he mentioned here. So, see, I have requested you, you can tell the assignment. I was requesting.
That's also come today.
Please help me.
Pardon to mention, my lord, one fresh CRLMC, matrimonial dispute, my lord, compromise, my lord. I've given the memo.
Compromise?
My
498A.
498.
Yes. Yes.
Section 1 to 10.
Item 5, my lord. Item 5, adjourned to 2 weeks after.
5, okay. On request. Petitioner. So enters evidence by taking no objection from the earlier counsel.
My lord, item number 4. My lord, amicable settle in between party. Affidavit already filed. My lord, kindly fix a date to both the party present for your lordship.
What are the offences?
My lord, 506 and other offences.
At least the second week or yes.
Next week any day, my lord. Next week any day.
Not week. Next. It's not on the convenience of the accused.
My lord.
Convenience of the court.
My lord.
Next week. I'm going to hear of you. Second week.
Item 2.
If you can bring them today, I am ready to do it.
My lord.
Then, yes. Yes.
Item 2, permitted to withdraw with a liberty to file better.
Permitted to withdraw with the liberty to file a better petition with better particulars of the documents. Yes.
Item number 3 may be adjourned to 3 weeks after you lordship the conducting counsel present.
Why, madam?
Your lordship, the conducting counsel could not be present.
Okay, on the request of counsel for the petitioner.
Item 6, 12 and 13, my lord. One matter was sent for mediation. So let's keep it to some other day.
6,
12 and 13, my lord.
2, 12 and 2, 9, 6.
Sorry, 6, 12, 13.
6, 12 and 13. Mrs. Rahul and counsel for the petitioner submits that a connected matter has already been sent to mediation. A mediation process is going on. Hence, lease the matter after mediation. Second week, they second week, third week, they
Third week की fourth week के रख दिया.
fourth week, last week, last week of April.
Right.
Kitchen day matter same auto come.
My lord, item 10, the file has been transferred. The name of GNC of assessor may be deleted.
Which one?
Item 10.
10. Okay, somebody has paid. Yes.
Item 11 to 25.
17 million. Accepted.
On the request of Roland counsel.
My lord, item 11, my lord, kindly adjourn.
11?
11, my lord.
Yes.
Next any.
11. Urgent. All these matter will go to June, huh? Yes.
26.
Those who are asking for time, it will go to June. Simple. Yes.
26 to
30th. June. Yes.
Also, may I make a mention, your lordship? Bigger pardon to make a mention.
45 to 49. 50 to 55. 56 to 61.
Item 57.
Same request.
Plus item 57, I'm appearing for opposite party number 2, your lordship.
57, huh?
Your lordship.
Are you opposing?
My lords, because they have taken four times adjournment, they have sought.
There is, then you have to.
They have stayed in one civil proceeding. my
Okay,
lords.
let it be. Let it be. I'll take it as there. It's done. Yes.
60 to 65.
Pardon, your lordship, to make a mention, your lordship. I beg
Any
your
mention
pardon,
is
your
missing? Yes.
My lord, may I
your
mention?
lordship.
Yes.
My lord, the criminal MC number 482 of 2025, my lord directed it to be listed on 12th March, but it has been deleted, not listed.
Which matter?
This is vigilance matter, my lord, criminal MC number 482 of 2025.
Monday. All these matters will come on Monday.
My lord, kindly have it on not Monday, not this Monday, my lord, have it any day, other day.
You tell me on Monday, I'll accommodate. Tell me on Monday, I'll accommodate. Don't worry.
My lord.
Tell me on.
Your lordship.
Let me finish. Let me finish
Let
this.
him.
VC things. Yeah?
Lordship,
Yes.
one phrase,
Yes, right, yes.
one phrase admission matter, your lordship. CRLMC number 930 of 2025. Lordship, date fixed in the court below is 17. That's why there is the urgency, your lordship. Here the court has in a 138 proceeding, cognizance has been taken since 3 years back, and now the amendment petition has been allowed. The matter was kept for framing of charge, your lordship. And that's the urgency, your lordship. Kindly take up on Monday.
What great urgency in 138 matter? If something happens, you tell me, I'll set aside that also. If you
Your
have a
lordship,
case.
matter kept for
Why
charge
do you-
of 17.
Don't
Your
worry.
lordship,
Even if charge is framed, the court is not powerless. Charge also can be passed. Why do you worry? I'll take it up. Give me a memo, I'll take it up.
Yes, sir.
Okay.
Grateful.
Any mention?
Item 53, my lords.
53?
I missed the bus, my lords. Item 53, Mr. Marana is absent, but this is a
Mr.
case where your lordship directed the state council to obtain instruction.
Then I'll just adjourn because Mahana is not. I'll simply adjourn. Huh? Mr. Mahana. Okay, 53. Any matter, Mr. Mahana is
Yeah,
appearing?
unavailable, lords.
Huh?
Not available.
I know. Any matter he is appearing?
No,
Correct.
item number 1, he's appearing, but I'll have a mention. My lord.
Okay.
But I'll
Okay.
apply, your lordship.
Yes.
Item 1.
Wait, please, your lordship.
Yes, sir.
That's if the.
Lordship permits, my lord, may submit one line. My lord. Lord, this is that case, my lord, against rejection of a discharge application. They have preferred this petition under 482 and layout 239, my lords. And my lords, in the meantime, my lordship can see the last order sheet, my lords. They have filed some kind of additional documents, my lords. My lords, in the absence of Mr. Morana, I went through the files, my lord. The additional documents I will spare.
I'll
copy,
adjourn
lords.
because Mr. Mahana is not. Simply adjourn.
I need a spare copy of that.
I'll do that in a minute.
Yes. On behalf of Mr. Niranjan Mahana, it will meet for adjournment as in before, lease the matter. Yes.
But herein, there are two connected matters wherein mediation has been going on and the next date of mediation has been fixed to 4/4/2025.
After 4/4, mediation process is going on. Before mediation center matter will be listed on 4/4/2025. Release the matter after 4th week last week.
It's a prequel stay off for the proceeding.
Already,
But it's in the connected matters, is it? This has come for the first time.
in the connected matter.
Yes.
No record. There is no record of legal connection. In this case also, there is no record of
Let's
charge sheet,
provide the
only FIR copy. How stay will
Mediation is going on in that matter, it is stayed. Why? How does it make difference?
no stay formal.
Then I'll have to issue notice. So many things happens. Wait till if anything happens, move application. I'll do it. Mention it. I'll do it. Mediation is going on. Ideally, nothing should happen.
Connected case.
Release the matter along with connected matter.
Yes.
Since
Please give the number.
let counsel for the petition submits that in the connected matters, a interim order has already been passed. In that view of the matter, no interim order is required in this present matter. Give the particulars.
But as an adjournment application may be allowed.
I have written that in view of the interim order passed there, no interim order is required. Obviously, it covered. Yes.
Please, your lordships. The petition is challenging the order of cognizance, your lordships. Here, your lordships, there is an
Take the
FIR.
number, Take the number from connected.
Here, your lordships, there is an FIR and counter FIR. In the counter FIR, your lordship was pleased to issue notice and stay the further proceeding. Your lordships, that the CRLMC is 2642. And in that case, my learned friend is appearing.
I've got the petitioner and I have the instructions to
What
appear.
are the offences?
Your lordships, the offences
Offense.
are 341, 323, 294, 353, 506, 4. There are lordships. It's an official dispute. The one person was the junior engineer, the other was the executive engineer.
Petitioner
had
is
a-
the junior engineer and the OP2.
Why are you not settling?
What, my lord?
Lordship may call up both the
Both the
matters
parties.
on board, my lords. Both the parties will be present before lordship.
They're willing to compromise.
They're willing to compromise.
Oh, then I'll put it.
Lordships.
Come on 21st. I'll
My
lords, can it be on 25th, my lords? This
Okay, 25th. Come on, 25th. I'll settle
my lords, they're willing to settle it.
both the matters number you give. I'll
2642.
2642, 2020.
They are
My lords.
They're willing to
Official-
settle
They're
it.
willing. They're
That is
willing.
the reason I brought my friend, my lords.
Both are willing, my lords. And
I'll record their statement and dispose of both.
my lords. my lords.
Lordships.
25th.
May I pray that the trial is on and adjournment application is necessary.
Adjournment application. Then
If
counsel
necessary.
The same was also
on
part in
advance
the-
notice. On advance notice, the opposite counsel for the so-and-so entered appearance for the opposite party. Both the counsel conjointly submits that in the connected matter, notice has already been issued and interim order has been passed, and the parties are willing to settle the matter amicably. Lease the matter so and so. In the meantime, proceeding before so and so is stayed. Yes.
Along with CRLMC number, my lords, 2642 of 2024.
नंबर रख दिया 25 किलो भेज दिया ठीक है
Pleasure.
Yes, yes, what
यस
Confirming order of municipal court petition CRPC for release of the bank account and checkbooks seized at the time of the investigation.
बैंक अकाउंट
And checkbooks.
ओके
Confirming order.
कंफर्मिंग ऑर्डर
Yes, sir.
in the banking account is there any balance is there
That part, no inspection.
Hmm.
But
has he said anywhere
in the application, there is no.
if there is no balance what will you do with the checkbook you give the checkbook and if there is any balance you tell me if it is not balance let him
For the report from the police, CICD. But the CICD has refused not, there is for further investigation that is kept in by the investigation. That report is stated in the YouTube model.
चलो nobody is there so देखते pass और करो एक बार
Pastor,
pass और करो yes
40.
Proceeding is under challenge, madam. Initially, FR under section 294/506 from 3 of SCN Street.
yes
after investigation, investigation will also charge sheet submitted by exonerating that 3 of SC and ST Act. Only on the section 294 and 506. But the London magistrate has taken cognizance by adding that 3 SC ST and also is summoned for the accused, summoned to the accused. If a lawsuit have a glass to the FAR law, that in fact it's arising out of a political dispute. I'm a Gram Rozgar Sabha.
You are questioning the cognizance order insofar as the section 3 is concerned.
No, yes, sir, but I'm challenging the proceeding because there is every chance of possibility of compromise because it's arising out of a political dispute. I'm a Gram Rozgar Sabha, and if lawsuit have a glass.
I'll issue notice, let us see. I'll issue notice because there is a scope of settlement, the political rivalry, whatever.
294, 506, and 3 of SC.
I'll issue notice. Only cognizance is taken now. What is the stage?
Stage the cognizance has been taken. Now the case is also ready for.
I'll give a short date. You file the process. We'll try and settle it. Okay. First week, second week. Issue notice, second week. You come.
If necessary, I will find a adjournment application.
If I pass the interim order, then you will be vanishing. That's the reason.
No. That I am also interested to pass it.
That's the better idea.
As I'm a government servant,
that's a better idea. So I can give little early date. File the process fee and I'll finish it.
Because the instruction what I have received, the case is posted to 2nd of April. That's what I'm.
On the second, let him move an application for adjournment. Second week, second week, third week.
By Monday,
file the process. Yes.
15.
Let's refer pass over, madam.
16.
In this case, the opposite party number 2 held a one case before the one case under 138 and accumulated.
Yes.
In that case, I am the accused and every that I have appeared and filed a Hajira Miller.
Yes, yes.
But unfortunately, I have undated 2/9/2024 Miller. I have filed a petition for a time.
Yes. What happened?
But
15, he has filed a time petition before the learned court below on the ground that he was suffering from acute spinal and
so that is rejected.
That has been rejected, imposing 500 cost on the.
So you are agreed by the 500. 500.
But
for 482.
Every date I have appeared in the.
That's right, but only 500 rupees cost is imposed. Therefore, you come to the court in 482.
Therefore, he has filed it there to waiver of that 500 rupees.
Why are you wasting time on this? Why are you increasing burden of the court? 500 rupees. You might have spent more than.
What that is but every day.
That everything all right. I'm with you 100%. But for 500, why have you come here? Merely because 500 cost. You have to be little sympathetic to the institution also.
That is.
People are waiting. See, don't do that.
On the genuine ground, I have filed the time petition.
This is amounting to a disservice to the institution. 500, pay the cost 500 and you are 482 proceeding. How much you might have spent it? It's an ego issue. What can I do? I just record your statement that you would be appearing in the court and every day. Learned counsel for the petitioner submits that he had moved an application. He is the accused in a proceeding initiated by opposite party under section 138 NA. On every date of hearing, he has been appearing before the court. However, on 2/9/2024, he moved an application seeking an adjournment. The Learned Trial Court, although allowed the application, however, imposed cost of rupees 500. The petitioner is agreed by the king. In view of the fact that the application of the petitioner has already been allowed and only a meager amount of 500 rupees cost has been imposed, I am not inclined to entertain this petition. Then counsel for the petitioner seeks to withdraw this petition and makes a statement that his client would be appearing before the trial court on every date of hearing. Yes. Yes.
Item, sir, item 80.
Item number 18 on behalf of Gopal Krishna Mahanti, seek for an adjournment, Your Lordship.
On behalf of Gopal Krishna Mahanti.
The same matter, 21 also.
21 and 29, my lord.
Seeks an adjournment. 21 we got you. Adjournment.
And 29 as well.
29,
21 and 29 as well.
21, 29, everything. And it will go to June. Yes.
Okay.
May for this. Yes.
19.
Item 19, my lord, maybe please to pass over the matter, my lord.
20.
My lord, I beg pardon, my lord. Once Monday, I filed that again. Monday, Monday. I know.
Where is your file?
My lord, that was misplaced. For that reason, I pray.
Okay, learned counsel for the petition service that he has misplaced his file and wants to reconstruct the same. Hence, he seeks for an adjournment. Leaves the matter. Same we can look at 24th wala we can reconstruct. Take
my lord,
take it from
22.
My lord, 20. 20. 20 remove. Sorry, my lord, sorry. Sorry, my lord, sorry.
Which item is yours?
26, my lord.
Wait, don't create confusion.
My item is 26.
He has an habit of reading some other file. Your friend. He'll start reading some other file and get it now. I'm telling you. As it is, you are confused. And if the people will create confusion, you will read something. Yes. Nice. This is in the lighter side. Don't take it seriously. Yes. Yes.
My lord, in this case, I challenge the order of cognizance passed by the Hon'Ble court below. Matrimonial dispute. Petition number 1 is the father-in-law.
I need to notice. Matrimonial dispute.
Party Korich.
I need to notice.
Again.
Right. Bring them. Bring them. Okay.
My lord, further proceeding.
Application look. Application for that. What is the stage, by the way?
My lord?
What is the stage?
Change.
Stage,
my lord, notice issue hoichi last date notice issue hoichi number देगी time नहीं चल देनी
22 सरला
22 वाला बा
22 कर दो
23.
only one witness recalled.
Including the victim.
Victim I will dismiss. No, so far as victim is concerned, will turn down. The other witnesses will allow.
He has to come the questionnaire in the brief also.
Let him come then. Yes. Pass off.
24.
The petitioner challenged the cognizance order taken 11/2/2002.
Yes.
Petitioner was a student of Bhadra College, and as per the FIR, on consequence upon the accidental death of Vidyadhar Pradhana, a student appearing +3 final year arts examination on a railway track, some unruly students secretly instigated and mobilized other students, and upon the FIR of the principal Bhadra College, FIR was a registered occurrence was 10/4/1999.
It's a ragging.
No, sir. It is not ragging. Somehow a suicidal death railway track re he got a +3 final student. Thereafter, principal filed that the occurrence was 10/4/1999, and the FIR was filed against the students on 11/4/1999, and the running page of the FIR at page 12.
Now, what is going on in the trial now?
No trial has been commenced, and a
99 incident.
Milord, and a
charge sheet filed on
charge sheet filed on
2002.
charge sheet number 6 filed
10,
on
10/1/2002.
10/1/2002.
Nothing is happening.
Nothing is happening till today. And
99-inch
two-
FIR.
and
2002.
and my lord, I want to submit 2 persons have been cognizance against two accused has already been set aside by this honorable court.
What is that?
Kindly.
The petitioner is an accused in one of the accused in FIR number 4.
Kindly running page 34.
Also registered on FIR registered on 1 minute registered on 11/4/1999. After investigation, charge sheet has been filed on 10/1/2002. Then counsel for the petitioner submits that. Where is that order, sir? Yeah.
Sir, cognizance.
LMC number 2432 of 2023.
Sir.
Filed order dated 25.
Where is that page?
Sir,
36.
Sir, page number 34 against Ramakanta Mahalik filed order dated 7/5/2002 in criminal miss case number 1439/2002.
It has been quashed, huh?
Yes,
It has been quashed.
there are 2 pages.
And
Insofar as
and another accused, Vichitra
give
Jana.
in writing, sir. Give in writing. 3 accused. Now, when it was.
Sir, one order has already.
Please give in writing. I'll write. Please. Insofar as other co-accused persons are concerned, the case against them has already been quashed. Already been quashed. Give in writing, huh? Quashed by this court by order of the attention by order issue notice to the opposite party state. Don't say it fully. In the meantime, proceeding before so. You have been absconding.
I have been I was not aware about involvement of. I was student since 26.
Okay, simple issue notice. Let us see what can be done. Yes.
Sir,
25.
NVW has been issued.
NBW has been issued.
When?
Stay operation of the.
Where is NVW? Show me.
Sir, production of the accused persons was issued on Sir, on 15/12/2002.
15. Let counsel for the petitioner submits that on 15/4/2002.
15/12/2002.
15/12/2002. The Land Trial Court has issued notice to issued MBW against the petitioner. The petitioner has no knowledge about the same.
2002.
At this stage, he has challenged. He has filed the present petition seeking quashing of the entire proceeding. Notice also
Sir, that is
on instruction, the counsel for the petitioner submits that you appear surrender before the court below on or before 15th of April.
15/12/2022.
Sir, that is 22.
15/12/2022. Appear before the court below on or before 15th of April. And resort to the remedy available to the counter law. Till 15th of April, also the execution of the NVW order passed by the trial court by the order dated 15/12/2022 shall remain stay. Please the matter on 15th April, 15th April, 17th April. You appear on or before 15th April, you appear in trial court and move application. 17th, I'll take it up. Yes.
25.
Following the order of cognizance under the 130 NI Act, there is nothing any material regarding the 130 NI Act. No cause of action is arise. How the check is to be presented before this court, that is already not written. That's why file a order of cognizance is maybe questioning for the order of cognizance or challenging it.
What are the grounds?
Nothing any stated in this petition, Your Lordship.
Where is the complaint?
My lord, complaint is annexure. Annexure 2, Your Lordship, page 17.
Yes.
Dispute regarding the matrimonial uncle and the OP number 2. Those who are filing this complaint petition, after death of the matrimonial uncle, he lost a complaint against this petitioner, my lord, regarding collection of the money to 20 lakhs. Only the fact of the case there, 5/4/2023, your lordship, page 18, para 8, your lordship. There are the dispute regarding the matrimonial uncle and the
No,
opinion.
that's all right, but the complaint, just see the complaint.
Well, complaint case.
You had issued the check, it is dishonored, notice was given,
Kindly,
you, it was served on you,
yes, your
you
lordship.
did not reply.
Lordship is
All
the-
these things are written, how
Lordship
can
is
it?
right, your lordship, but dispute regarding the matrimonial uncle and the opinion number 2, your lordship. After death of
That's
the
a
matrimonial
different
uncle.
story. How can I cross the 138 proceeding?
Petition has not issued the check, your lordship. Only check has obtained by the matrimonial uncle.
Show me your reply to the notice.
Issue notice, your lordship.
No.
They may appear before this.
138 matter, not
Two cases there. One is the 47 and another 50.
Maybe, but you have to satisfy me. If there is a case, then only I can issue notice.
My lord,
Not the usual thing.
another petition is 47 altogether, my lord. Taken together.
Try to appreciate. In 138 NI Act, cognizance has been taken.
My lord.
Unless you make out a case, why should I issue notice?
My lord, only ground is that they have not written any cause of action arise. How I check is issued to this complaint petition and another dispute.
See the complaint. Have you read the complaint?
My lord.
Everything is written.
20 lakhs the accused issue check.
138 NI Act ପାଇଁ ଯାହା ଯାହା ଦରକାର ସବୁ ଅଛି complaint ରେ.
ସେଥିରେ ସେ ଆଜ୍ଞା କେବେ ଦେଲି କଣ କଲି କୋଉଥି ପାଇଁ ଦେଲି ସେ ବିଷୟରେ କିଛି
It's not necessary. He will prove. He might have given the notice to you. Notice has been served. Have you replied to the notice?
Only one ground, your lordship. Matrimonial, after death of the matrimonial uncle of the opinion number 2, those are filed the complaint case. They lost the complaint case against me, your lordship. They were the partner, business partner
All
of
these things may be your defense, but while you
defense is
challenge the cognizance order in 138 NI,
my lord, fact is true, your lordship. He has not issued any other check to this complaint, your lordship. Lordship, call for another complaint petition is that 50 CLMC, another is the 47, and taken to same petition.
I can't make you understand.
Same petitioner.
So, show me the reply. Have you given reply to the notice?
No, my lord. Only 205 is allowed. There
reply to the statutory notice under section 138.
No, I have not replied anything.
Bracket B. Have you replied?
No, my lord.
Then the presumption also operates against you. I will have to write something and not that you file the petition now, issue notice. Not like that. You satisfy. If you have not read, I will accommodate you. Read it and come. Make out a case.
My lord.
Okay, I'll just simply adjourn this matter, both the matters. Please read.
Today is listed is one matter. Another matter is 47, your lordship.
Item 47 today.
No, my lord. On the CLMC 47 of 2024.
Okay, both the matters I am listing it. 2 weeks for you, both the matters. And prepare and make out a case.
My lord.
Okay. Simply adjourn. Yes.
26.
May I please your lordship? My lord, the opposite party filed an application under section 125 CRPC for maintenance, my lord. When that petition is pending, my lord, the petitioner filed an application that the said petition is not maintainable because the opposite party, who is a daughter of the petitioner, is a major. So she is not entitled to get the maintenance according to the section 125 of CRPC.
Yes.
So after knowing this, he filed an application, an amendment to amend the provision of law in the 125 CRPC application.
Amend the provision of law.
My lord, if your lordships kindly see the proposed amendment, my lord. That is annexed.
Amend the petition or amending the provision?
Provision, my lord.
That is provision.
My lord. So that application was allowed. Against that, I filed this application.
Show me.
My lord. That proposed amendment is annexed to
yes.
page 14, my lord.
Then he wanted to add section 20 of subclause 3 of Hindu Reduction and Maintenance Act so as to maintain the application
125
for seeking maintenance insofar as the child is concerned.
Opposite party is the daughter of the petitioner.
I understand it.
My lord.
I understand. What is wrong in it?
My lord, my humble submission before lordships.
Are you disputing that you are not married?
No, I am not disputing, but I am disputing only that 125 application, the CRPC application is not maintainable because she is major, my lord.
She is your daughter. What is this?
My lord.
What is this?
My lord, now she's aged about, at the time of filing, she is 20 years.
23 years.
Now she's 23 years.
She is your daughter?
She is my daughter.
Just
admitted.
forget about 125 or 133. Forget. Will you
My-
not maintain her?
I am
She is a
maintaining.
young girl. She must be. Well,
I am also maintaining.
and you are
As per the-
forcing your daughter to litigate also.
No, I am maintaining as per.
She, at this age, she was instead of coming to the court and fighting with you. Don't do that.
My
I
lord,
will not enter. No.
my lord, my humble submission before your lordships, my lord. I am maintaining as per the order of
You
your,
do whatever
your
you do,
lordships,
but-
your lordships.
You can fight it out with her wife.
No,
That's a different story. Don't bring your daughter to the court.
No, because there is a divorce, my lord. I am not disputing, my lord. I am not disputing. I am giving, my lord. With the lordship's permission, the nomenclature should be converted, my lord. Because my
Tell that court.
my lord,
Why should I do?
if your lordships kindly see the impugned order, my lord. If your
I
lordships
have
kindly
seen
see.
it. I've seen it.
If your lordships kindly
I
see
have
the
seen it. I
impugned
will
order,
not
my
go
lord.
into technicalities and all. You move appropriate application.
My lord, suppose
And you are determined to bring your daughter to the court
my lord, I
by
bound
this 125 proceeding or 23 proceeding.
23 of the CP, जो Hindu marriage.
Now you want that
adoption
it
and-
should be instead of this nomenclature, it should be that nomenclature.
No, no,
That's what you
she want, my lord, she want.
But
and
the
she
fact
ha-
remains that she will be fighting.
No, no, my lord, she want and she filed this to amend the provision, my
Let her
lord.
do
My humble submission before your lordship, suppose I fail in that the CRP, then what can I, under which provision I file this
I wish
application?
you
So,
should fail.
so my humble submission before lordships, the nomenclature of the said the 125, that is CRP. Now he amend. That is converted to the section
Then
20.
you have to tell that court that it changed the nomenclature. How can I in a 482 proceeding I'll keep on changing nomenclature here?
My lord, with lordship's observation, my lord.
For the petitioner seeks to withdraw the petition to move appropriate application before the trial court for changing the nomenclature of the petition after the amendment is allowed. Liberty granted to the petitioner. With this observation, the petition is disposed of. You do whatever you want.
Seven.
Maybe.
The petitioner filing the petition for the quashing of affair of the under section 419, 420, 467, 468, 471, 120.
What is the stage?
Allegation, both all accused person, 5 accused person under the bail, my lord.
Not bail. Investigation is going on.
Yes, my lord.
Then how can I?
Charge is not filed, my lord.
Therefore, I can't quash, madam. I can't quash because investigation is still going on. And other accused persons have already got the bail. You also apply for bail, you will get it. I can't quash it. Madam, the petitioner is seeking quashing of the FIR number so and so. Sahadev Kunta, PS case number 518 of 2013. The investigation of the case is still going. Let counsel for the petition submits that the co-accused persons have already been enlarged on bail. Be that as it may, since the investigation of the case is still going on, I am not inclined to interfere in this matter in this case. Hence, the same is dismissed with liberty to the petitioner to resort to the remedy available to him under law at the appropriate stage. Yes.
28. May I please, your lordship? Lord, in this case, my lord, the quashing of affair of offence under section 363. Lord, now the petitioner and the opposite party number 3 residing together and they are married to each other. For that matter, I have annexed the 161 statement of the opposite party number 3 at page 15, my lord. She is clearly
They are married.
Yes, my lord. They placed a child, my lord.
Bring them, I am issuing notice.
Yes, my lord.
Issuing notice.
But opposite party number 3 already appeared through our advocate, but your notice has to go to opposite party number
Notice has
2.
not been issued. I'll issue notice to
Opposite party number 2, my lord.
I am the opponent too. I am the opponent too. On behalf of Virendra Mal. Opponent 3.
3. For 3, she an advance notice is appearing. Mrs. Marana accept notice for the 1. Notice. And I married.
I am residing with my husband.
Then I'll say the proceeding.
Yes, yes, ma'am.
The counsel for the opposite party number 3 and the petitioner conjointly submits that the parties have settled the dispute. The petitioner has already married with the opposite party number 3. on the ground of the settlement, the sequestment of the present proceeding, since the matter on certain such day, and in the interim proceeding before so and so state. Yes. Bring them.
Yes, yes, ma'am.
Yes.
31.
Here. Yes, madam.
My lordship, this is under section 71 of Odisha Excise Act, my lordship. Total, my lordship, 500 liters of idle liquor was transporting on a vehicle, and they filed a petition for the release of the vehicle. And the confiscation proceeding is still pending, my lordship.
Pending.
That, my lordship, the DMS rejected.
The petitioner in this present petition is challenging the order dated
29/6/2024
passed by SDGM Jaipur in Miss case number 59 of 2024, whereby his application for under 457 CRPC seeking release of what?
Vehicle, my lordship.
Vehicle
Bolero.
has been turned down. Mrs. Marana, learned counsel for the state, submits that confiscation proceeding is still going on. Later obtain the instruction regarding the stage of confiscation proceeding. Release the matter in May. Yes.
32.
No, please.
May I please your lordship through virtual mode, my lord. The petitioner challenging the order dated 27/8/2024 passed by the learned court below in one complaint case bearing number 2277 of 2015 in rejecting the petition under section 311 CRPC, my lord. In a proceeding under section 138 NI Act, the complainant being the PW1 is his sole witness, and the complaint PW1 has not been full-fledged manner cross-examined. So after
where is the cross-examination?
I filed the questionnaire, my lord, at page 18, my lord. Page 18, I have furnished the proposed questionnaire. Only that much, nothing else, my lord. Proposed questionnaire is to be put. And the stage of the case is also, the just defense evidence will start.
Issue notice to opposite party number 2, written evidence so and so. Short date 7. Yes. I issue notice, let us come. Yes. Yes.
33, my lord, same.
Issue notice. Short data. Yes.
34.
May I please? This is the compromise matter. Sir.
Compromise. Offense?
Of
Minor offense. 147, 148, 324, 323, 149.
Page 14.
Page 14.
They are there?
Yes, sir. Page 14. That is reflected.
Who are they?
One petition is one. 3 persons are informant.
3% informant.
92. Since 92. Election.
Election company during.
What is happening there in trial court?
Counter case.
In this case, what this FIR was registered when?
92.
92.
My lord.
And what is happening in the trial?
Trial is nothing else. My lord, I have given the last page. Kindly give a glance to last page. Because due to non-occurrence, that was in dormitory in the year 2021. Last page. My lord.
Nothing is happening in trial.
Nothing is
Record your statement.
My lord.
Let me verify because it's an old matter.
No, I have given the copy.
What will you do? See the offenses.
Page 17. Page 17.
See the offenses. You will be relieved, they will be relieved, the court will be relieved.
My lord.
Relax. Even if I have offense 92.
No, my lord, absolutely correct.
What? See, ultimately these people are going to be acquitted. Pardon on the court, I tell you.
92 Mukta.
And it is the failure of the, I can tell the system.
My lord.
Failure of the system. And the mere pendency of these kind of cases from 92 itself, the process and the trauma itself is the penalty for these people. Cases were pending for such a long time.
Out of 9, 1 petition.
No. One is before this honorable court. What happened in the meantime, other persons are acquitted. And we have taken ground.
Yes.
Suppose nothing.
Total like you accused?
9.
nine accused. All acquitted except one. One is because he would not have absconded.
There is no
Because
record.
question is that the dispute is the name.
Regarding acquittal, there is no record.
Why the, there is a confusion in this.
Naare dispute thela bili sera pending rahila.
FIR वाला नीट नंबर हर एक
Acha, what is he doing, by the way? Rushikesh?
my lord.
Who is Rushikesh? What is it? Number 2, 3, and 4. At the instance of private opposite party number 2, 3, and 4, the FIR number so and so. What is the FIR number? First information cognitive FIR number.
Hmm? 65 of 1992.
60?
65.
No.
63, sorry.
63 bracket 9
Bracket
63 FIR number 63 bracket 9 92 dated 20th 20/5/1992. It came to be registered against 10 accused persons. After investigation, the charge sheet was filed in the present case on
11.
11 charge sheet filed on 18/8/1992.
Yes.
18/8/1992. The other accused persons, the 9 accused persons were apprehended and they faced the trial, and all of them have been acquitted. By wide order dated, we have acquittal order.
Acquittal
Judgment. They have been acquitted. Insofar as the present petitioner is concerned, she was shown as an absconder. The counsel for the petitioner submits that there was a confusion in the name, parentage, and the address of the petitioner. Therefore, the NBW could not be executed. When the matter stood thus, when the petitioner came to know regarding the pendency of the present case, then he has approached this court by filing the present petition for quashing. He has also seen the dispute with the complainant. First time this is coming on advance notice. The entered appearance for the complainant. The petitioner and all the complainants are present in the court, being represented by the respective counsel, identified by them. They also filed the self-attested copy of the other card. The allegation against the petitioner is so. The counsel appearing for the parties conjointly submits that trial in the present case has not yet been commenced. Regarding head to the nature of offences, which are very minor, and the fact that the case is pending since 1992, I'm inclined to entertain this petition. The state council has opposed the petition on the ground that the petitioner is an absconder. Therefore, on the ground of settlement at the related stage, the FIR should not be quashed. The next one, the fact remains that the allegation against the petitioner is minor in nature and also minor in nature. Apart from that, the warrant issued against the petitioner way back in 1992 could not be executed, even though the petitioner himself is an employee of
FM College,
FM University.
FM University, yeah.
University.
Therefore, it is apparent that he has never absconded. Rather, the NBW could not be executed. Be that as it may, since the parties have now settled the dispute and have filed the affidavit before this court, the case of the petitioner is covered by the judgment of the Honorable Supreme Court in Jan. Next paragraph. The opposite party number 2, 3, and 4 have filed a separate affidavit dated the 13th March 2025, commonly stating agent, Put out to paragraph 1, 2, नहीं put out to paragraph नहीं जो हाँ ठीक है 1, 5. 1 to 5. Regarding head to the aforementioned facts and circumstances and submission made by the counsel of the bar, I'm inclined to allow the petition and pass the charge sheet dated soon also, and the consequential proceeding arising therefrom for the present petitioner, subject to the present petitioner paying the 2,000 rupees each to the opposite party. 2,000 each. Yes. Yes.
You only respect to accused number 3 only.
So far as the petition is concerned, both Mr. Gaya and Mr. Maharaj, they become more persuasive on that side, Lords.
That is the reason they have been chosen here to be out of
Chamber belong for
35.
55, my lord. Application for recall under 311 has been rejected.
It's an appeal.
My lord, appeal because it is coming from the Special Court Act.
Okay.
From the authorized officer's order.
Oh,
Unconstitutional case,
yes.
my lord. I have filed one application under section 311 on the ground that on the posting of date of cross-examination from the side of the defense, my lord, prosecution witness number 3 was the IO. My lord, he has not been further examined on my illness, on ground of illness.
Where is that? Where have you said that?
My lord, I have stated.
Your
the
application is not there.
My lord, as it is an appeal, I can only file the, my lord, impugned order.
But where is the application? Let us see the application.
My lord, that has been stated by the learned court below. That what was there in my application. My lord, may kindly see.
My lord, this matter has a checkered history. If your lordship may kindly come to the impugned order, page 12. I'll just read the relevant paragraph.
On perusal.
Yes, ma'am. The sentence starting with on perusal. I'm just placing it. On perusal of the record, it reveals that on 16/8/2024, even though PW3 was present as the learned advocate for the opposite parties, prayed for adjournment. Considering the petition of adjournment was allowed subject to payment of cost of rupees 2,000, and the case was next posted to 17/8/2024.
Yes.
This is the first episode. Then what's the second episode?
Next day it was listed.
Yes. For 17/8/2024 for payment of cost of rupees 2,000 to PW3 and his cross-examination. On that date, the learned advocate for the opposite parties had neither paid the cost nor turned up to cross-examine him, PW3, for which his further cross-examination was declined, and the case was posted for filing list of witnesses by the opposite parties. This is the episode number 2. While the matter stood thus, the learned advocate for opposite parties had filed a petition under section 311 CRPC to recall PW3 on 6/9/2024. On 10/9/2024, the petition was allowed subject to payment of cost of rupees 5,000 to PW3 on 15/1/2025. Worthwhile to mention here that on 15/1/2025, as the learned advocate for the opposite parties did not prefer to pay the cost of 5,000 to PW3, my lord, this is important, or turn up to cross-examine him, his further cross-examination was declined and he was discharged. While the matter stood thus, my lord, the next page, the learned advocate for the opposite parties has filed the present petition to recall PW3.
My lord.
One more regarding non-payment of the cost. You pay the cost and do it.
My lord, second. This is the case of the year 2015. An examination of PW3 has started from 16/11/2016. And in the meanwhile, more than 9 years has been elapsed, my lords. And the opposite parties have not found time to cross-examine PW3.
My lord,
this is nothing to prolong the trial, my lord.
My lord, I am submitting. What has happened here?
1 minute. I am just wondering.
My lord.
Your 311 application was allowed, which is subject to cost of 5,000.
My lord.
You didn't turn up, you didn't pay the
price.
Right.
I only
Okay.
filed the application for an adjournment. On the
No,
ground
why have
that-
you moved another application?
No, my lord, on
You
that,
you should have simply
on
said
the-
that, yes, please allow me to deposit.
my lord,
them.
what has happened?
Twice, my lord, not
Although,
legal.
although
This has happened.
although the PW3 examination has been started since 2016, he only turned up on only 3 or 4 days. My lord, for some reason, for law and order situation, he has moved the application for adjournments. And when he turned up, I could not be present on the
Why,
ground.
what is happening? 2,000 rupees cost you didn't pay and didn't go. Thereafter you moved to application.
I have
for
already
the-
given only 5,000.
You didn't pay. Didn't go.
Only 5,000 cost I have to pay, my lord. That is, he's the IU.
You don't want to pay 5,000, but you
I
go
want
to the
to.
Supreme High Court.
I want to pay, my lord. On that given date,
Why
said
have you
that-
not gone that?
I said that I was ill, not that I.
Where from I get it?
I'm seeing that. My lord, kindly see page number 11. Page
11.
number 11 of the
Yes.
order. My lord, the second paragraph. The learned advocate for the OPs has submitted that on the date of cross-examination of PW3 as the cost imposed while granting adjournment could not be paid to PW3 and as because the conducting advocate was ill. The cross-examination of PW3 was declined and he was discharged on 15/1/25. He was submitted that as the PW3 is the most vital witness, he should be recalled for his further cross-examination. I only said that I was ill. Not that my intention was
cannot
never
be
that.
considered basing on one judgment of the Supreme Court. I'm just relying, Lordship, kindly have a look at. I have flagged it.
This is not my contention that I will not pay.
But your conduct is so bad.
My lord, only on 2 occasions I was not present. This is a
Repeated
fact.
failures to deposit the
But it
money.
is
and
also a fact that
both.
my lord, from
Lordship, kindly come to
2016
Para 37, my lords. I've just flagged it. Para 37 and 38 I'll be relying. I'm just placing it, my lords. There is a definite purpose in, Lordship, have it, my lord. There is a definite purpose in referring to the aforesaid authorities. We are absolutely conscious about the factual metrics in the said cases. The observations were made in the context where examination in chief was deferred for quite a long time and the procrastination ruled as the monarch. Our reference to the said authorities should not be construed to mean that section 311 CR.
No, this is all right. For not giving the relief, this is good. But for giving relief, what to do you think of that?
That my learned friend should produce some judgments on that.
My lord, I'll produce, no doubt, my lord. Our honorable High Court
Why
has
is this small thing, 311 judgments and all?
only on the ground of
Why will
illness.
not pay? How much you will pay? You tell me now.
My lord, the given amount
You
of
pay 25,000 cost.
My lord,
Yes,
25,000 is a
25,000.
retired employee.
Dismiss it.
Retired employee, my lord. Not
Let it be. You
my lord, I'll pay.
You have
Not
retired
employee can
I'll
come
pay
to the High
10,000.
not 1 rupees less than 25,000. Will you pay or
Yes.
dismiss it? Simply tell me.
My lord.
7,000 you have not paid so far.
No, 5,000.
You have wasted
2,000 I have paid.
2,000 and thereafter
Only 5,000 I have not paid on the ground.
3 applications.
Yes.
I will condone everything. You
Below.
pay 25,000.
Yes.
Yes, right on. Petitioner is agreed by the order dated 28/2/2025, whereby the application under section 311 CRPC has been rejected. The learned authorized officer, special coordination, while rejecting the application of the petitioner, inter alia observed as under para 12 on the perusal of on the para 12, sorry, page 12, on perusal of record, paragraph put that. Mr. Rizvi, learned counsel of vigilance, vehemently oppose the prayer made by the petitioner on the ground that the petitioner at the on the ground of the conduct of the petitioner. Enough indulgence has been given by the authorized officer to cross-examine PW3. However, at every occasion, the petitioner has been a defaulter.
Yes.
Has been a defaulter. The he further submits that PW3 has been examined
Since 2016.
16 and in between 9 years have already lapsed, and the petitioner in one pretext or the other is seeking either adjournment or absent from the court
In order to prolong the trial.
in order only with an object to procrastinate the proceeding. While confronted with the situation, the learned counsel for the petitioner has taken me to the para
2, my lord.
para 2 of the impugn order. which reads as an para 2, page 11, para 2. Para 2. He submits that on the day when the matter was on 15/1/2025, when lastly the matter was fixed for cross-examination, the counsel for the petitioner fell ill. Therefore, he could not cross-examine the witness. I have perused the impugn order and taken into consideration the submission made by both the parties. It appears that the application moved by the petitioner under section 311 CRPC has already been allowed, and the PW3 was summoned for 15/1/2025. On that day, neither the cost of rupees 5,000 imposed on the petitioner was paid, nor the counsel for the petitioner had appeared. Rather, subsequently, another application under section 311 CRPC has been moved. The fact remains that the application moved by the petitioner under section 311 CRPC has already been allowed with a cost of 5,000. However, the petitioner did not avail the benefit of that order. By paying the cost so imposed. Taking into consideration the
Just neither paying the cost nor appearing.
Entire fact of this present case, I am inclined to allow one more opportunity, a singular opportunity to the petitioner for cross-examining the PW3 and on a date to be fixed by the authorized officer. It is made clear that the petitioner shall not seek any adjournment on the date to be fixed by the authorized officer for cross-examining the witness. The petition is allowed, subject to the petitioner paying rupees 25,000 cost to be partly paid to 50% of which to be paid to the PW3, and the remaining 50% of the cost shall be paid to, where is the bar? Which bar? Is there any bar there? Bhubaneswar. District Court Bar Association, Bhubaneswar. 50% you pay there, 50%. 12,000.
Can it be reduced to something?
20,000. Make it 20,000. It will be very odd figure. Make it 20,000, 10 years, 10 years.
30,000 sounds good actually.
Let it. Yes.
Lordship, kindly observe, this is the last opportunity given.
I have said
grateful.
No further adjournment. It's further made clear that if the petitioner for any reason whatsoever failed to cross-examine the PW3 on the date to be fixed by the special officer, so authorized officer, special court, the right to cross-examine PW3 shall be closed for all time.
Grateful.
Yes. Please.
6.
Yes.
May I please for the Lord? My lord, the petitioner challenges the
36, my lords, the interim order is there, my lords.
Okay.
32
Let it be adjourned. Interim order to continue.
Hon'Ble.
Yes.
37.
Your Lordship, item 37, on behalf of Mr. Sarthak Naik, I'm praying for a Passover, Your Lordship.
Lord, as far as Passover is concerned, for the day, it should not be the Passover because I have come all along before your Lordship.
Yes, I'll pass it over, call him at 12:30.
Yes, sir. I'll inform.
Because there is a counsel from outside, huh?
Yes,
Call
sir.
at 12:30, okay?
I'll inform.
12:30. Yes.
38.
Yes. 38.
May I please, Your Lordship? My lord, I have challenged an application for discharging, for rejecting my discharge petition, my lord. My lord.
Let notice go, a copy may be given.
Vigilance is the party here. I had already served copy to Vigilance.
Fine, in this
Yes,
spare
I have
copy.
already served.
Let notice go.
Generally, I don't even issue notice if you don't have merit. But he is conceding. I'm issuing.
I had served the copy on Vigilance.
I'm issuing notice because he has to go through. I'm issuing notice. Otherwise, I will go into merit.
At my cost, I will get a spare copy.
That is not.
Give a copy. I'm issuing notice.
But it may be kept any day next week.
Man, just give a short date. Give a short.
Because it has been fixed to 17th, my lord.
Nothing great is going to happen. Yes.
No, it is
Right
fixed
on.
for charging of framing of charge, my lord,
Notice.
for 17th.
Then you will amend the petition that I'll also pass if you have.
I had mentioned it in my IA.
Okay, it's all right. We'll see. Issue notice, huh? Issue notice.
39.
My pleasure, Lordship. I'm before Lordship, my lord, I'm challenging the order dated of 28/11/2024 NBW. My bail came matter, my lord.
Give the dates. When you got the bail?
My lord, I got bail on 19/6/2018.
Okay. 28/11/2024. 500. Yes.
40.
Obliged, my lord.
May I please the lordship, my lord?
Yes.
Well, petitioners were initially issued 41 a notice, my lord. But learned judge by the annexure 35, my lord. Sorry, annexure for page 35.
41 notice, and 1/2/2025 NBW 500. Yes.
41.
In stay of NBW, my lord.
Yes.
I filed a miss case, my lord, today, my lord.
Page 35, Lordship, please go through. It should
41, no?
41, my lord, NBW was issued
My lord,
I am setting aside why unnecessary.
Sorry.
I'll set aside and go and appear.
Lord says
Obliged,
also
my
the order,
Huh?
page 35, the order, the explanation has been called for from the IO. Page
40, item 40 you are talking about.
40.
35.
Page 35,
Yes.
last paragraph.
Hmm.
This is traveled by the court of session.
The case is traveled by the session court.
Now
It is
on bail, according to
now
the
on bail.
issue and rule
According to
warrant,
the NBW warrant.
Before that, the first paragraph, last line.
What do you want to say? Tell.
Only thing you will hence call for extension from the IO. Why has been considered?
In his petition, you want release. His petition. Why it is not executed? Now he is appearing.
No, my lord, he is saying, as the offence are punishable more than 7 years, why 41 notice has been issued?
That's a different story.
Yes.
Forget. Now you appear. I will regularize it.
Yes.
41.
May I please, my lord? NBW was issued, my lord, 16/8/2024. Bail was granted, my lord, 26/2018.
What is? 500. Huh?
42.
The police officers are also like this, when 41 notice is to be given, they will not give. When it is not there, they will give it.
My lord, 41
You
notice.
might have managed it.
My lord, 41 a notice doesn't say that this for this offence.
Wherever 41 notice was supposed to be given, they will not give.
And this is a
And the
perfect
accused manages then 41 notice. This is what happened. That is why the trial court is correct asking
No,
for
my
it.
lord, the type is not correct.
Let him
Because
face.
of- Yes, ma'am.
Let him face. You are safe now. Let him face. Yes.
Lordship, petitioner was released on bail on 26/8/21. NBW was issued on 24/7/23.
20?
24/7/23.
23. Okay. 1000. Yes.
43.
Your lordship, the same appeal has been filed for the restoration of an RSA. and
Delay? How much delay? Do you have delay?
Lordship, it was disposed of, it was dismissed on 21/7/2022.
Is there any delay or not? No delay, no? Right. For the reasons stated in the application, the same is allowed. The RSA number 263 of 2022, which was dismissed for non-prosecution on 21/7/2022, is recalled, and the RSA is restored to its original file. Yes.
44.
May I please? Already in limitation matter notice was issued, my lord. Here, your lordship, kindly see the noting, the postal noting says, my lord. Limitation notice of opinion 1 to 7, 9 and 39 section return answer with the postal address always absent. Such notice return to concern.
Take dusty notice then. Take dusty notice.
Well, I got a Supreme Court decision larger bench. Their lordship says, I'm just reading.
Which one?
2007-6
Party name?
Party name is my lord. SCC Alavi Haji.
Oh, Alavid Kaji. That's it.
Their lordship.
A right address, if you have sent it, is to be treated as service.
Code.
I know.
lock যদি হয়েছে তাহলে sufficient হবে
I know.
just not available
I know, but where from I'll get that right address you have sent? The address, just compare the address between
because one of the appellant has appeared on the same address, one of the petitioners, the same branch, same family. Others.
Like just compare the address you have given in this petition and in the RSA.
Because all have died.
Then LRs have to be brought on.
ସେ ଅଲଗ ସବୁ notice ଯାଇଥିଲା
LRs.
ରିଟ୍ ପିଟିସନ ଯୋଉମାନେ ଥିଲେ actually ସେ 3 ଜଣ ସାରା died.
Read me RSA na? Read.
well read.
Item number.
All LR को notice 32 ଜଣ ନେଇଥିଲେ all LRs died.
Okay.
That's advocate also one advocate is appear my lord. One advocate appear notice state.
Who is appear?
LP Patra, SP Swami, S Patra, and N Ponda also appear. For what? For whom they appear? The lordship
Just check it up and list it after 2 weeks. We'll see. Yes. Just check it up. If their names are there in the list. You just intimate them. No, you tell me in the.
Only my lord, only 8 baku notice because it is written unknown my lord. So I want to take notice on 8 only. Other sufficient in your with the larger case.
Let him. Then counsel for the petitioner is steps may be taken to serve opposite party number 8.
8 only.
8. In the petitioner is directed to furnish the correct address of opposite party number 8.
8 one.
In so far as the service on the opposite party numbers
1 to 7, 9, 13, 16, and 11, 12 months
are concerned, the postal endorsement indicates that the notice could not be served because the addressees were inverted comma always absent. Let counsel for the petitioner by relying upon the judgment who give that judgment to the judgment judgment submits that the service on opposite party number 1 to 7, 9 and 13 and 16 shall be treated as a sufficient service in view of the law laid down by the Supreme Court, laid down by the Supreme Court. Service on the same, the respondents are taken to be sufficient. The service on opposite party number 8 is not sufficient. Therefore, these steps.
10 and 11. 10 and 11 also sufficient.
Service complete. Okay.
On utilized copy, maybe utilized. On utilized
copy of
maybe utilized
petition may be utilized for the purpose of answer respondents. Okay.
To notice to the opposite party, but inadvertently that opposite party number 7 to 15, they are the proforma opposite parties. So notice would not have been issued to them.
So, would you like to drop them? At your risk.
At my risk. Another submission before your lordship is that the dismissal order which has been passed for non-filing of certified copies defect on our part, not supplying the, not curing the defects. So the read petition has not been admitted and notice has not been issued to the private opposite parties. For that reason, may I submit the opposite party, the state is the opposite party number 1. So let it be restored. If your lordship is pleased to, if the read petition is succeed, then notice has to be.
Due to non-removable defects, the read application is dismissed. Lordship, if state is.
Then I'll restore it.
Yes, your lordship. Yes.
Who are the proforma respondents?
Proforma respondent, your lordship, opposite party number 7 to 15, your lordship.
service on the pro forma respondent number 7 to
15, your lordship.
15 is not sufficient. And counsel for the petitioner seeks to drop them from the area of party at his own risk. Risk. Insofar as CM application is concerned, for the reasons stated in the application, the same is allowed. The order dated, where is the order dated?
Order dated, your lordship, 15/10/2008.
18.
Yes.
31/7/2018 passed by the passed in WPC number 27177 of 2017 is recalled. The writ petition is restored to its original position. What about the IA?
That limitation is there.
No, delay, how much delay?
Delay is there, your lordship, for 2018. I have filed it in India 2024, 21/10/2024. I paid something to the bar.
What is the delay, number of delays?
1000 days.
You have no opposition.
Lordship, facts remain the raising out to be under order section 15B of the Orissa Servant Settlement Act, Lordship. The private opposite parties is filed in 15B before the learned commissioner. That was allowed in favor of the complaint petitioner. Against that, my learned friend is selling that order, Lordship. The director consolidation is the necessary part. Here is the content by opposite party 1 year.
May you simply tell whether you have opposition to the condonation of delay application?
That's so far more than.
I don't know why have you filed a restoration. You can file a fresh one with the certificate copy and all. You have not cured the defects.
Reason being that that order is staring at us. For that reason, I have filed this. Lordship,
subject to payment of the cost to the bar, your Lordship may direct that may condone because due to
I number so and so for the reasons stated in the application. The application is allowed. Delay up to so and so day is condoned, subject to petitioner paying a cost of ₹10,000 to the High Court Bar Association.
It will be.
No, 1,000 delay. I'll reject it and you paid 10,000 to 10,000 to Bar Association. Okay. The writ petition number shown, writ petition civil number 27177 of 2017 has been dismissed by the coordinate bench of this court on 31/7/2018 as the defects pointed out by the registry could not be cured by the petitioner. Then counsel for the petitioner undertakes that he would cure the defects once the writ petition is restored to its original file.
Obliged.
46.
Yes.
Dismiss for non-prosecution.
Dismiss what?
CRLMC was dismissed.
CRLMC.
The reason I have indicated why it was dismissed is paragraph 3, my lord.
Paragraph 3?
Paragraph 3 of my petition, where I have indicated the reason for my non-appearance, and that led to dismissal of the CRLMC.
Counsel for the petitioner could not remain present in the court due to missing the number. Escape notice.
Escape notice.
Are you serious about?
No, I am. He is with me, man.
Who is your position?
State, Almighty State is there.
I'll
so
restore it.
prejudice.
Let it be for on merits.
No prejudice.
Entitled for hearing. I'll restore. Delay?
Yes, delay, my lord.
How much?
500 days. There was no occasion for me to know. When the trial court proceeded, I came to know that this has been.
Is there anything survived in CRLMC?
Yes.
What is that? What have you challenged there?
Stay was granted by this honorable court.
You are interested in the stay only, nothing else.
Your lordship, hear me, my lord.
What have you sought for?
I have challenged the order of cognizance, and this honorable court stayed the proceedings so far as I am concerned. Because there are other accused. So far as I am concerned, this honorable court stayed the proceeding. Being prima facie satisfied that OPID Act is not applicable to me.
Now, what has happened? See, it is dismissed long back. The trial might have proceeded now.
No. I'm keeping a track of it, my lord. I'm keeping a
track. You keep a track of that matter.
But after dismissal,
where you won't stay, you
after dismissal, I became clever, my lord. After dismissal, I became clever.
The problem is once stay is granted, generally this happens. You just forget it, send someone, get an adjournment, something may happen, but stay should continue. But you are very keen about the trial. You keep a watch there. You don't keep a watch here.
The matter of merit, I'm sure your lordship would like to hear the matter of merit, my lord. And I have a good case.
How much you will pay to the bar? 50,000?
50,000.
Because see, the senior counsel is appearing in a restoration matter. Why not 50,000 to the bar? You pay.
I leave it to your lordship wisdom, but I'm sure your lordship would not impose 50,000.
A senior counsel is appearing.
Exactly.
I can't disrespect you by imposing small cost.
It's the client who will pay, my lord, not the senior counsel who is going to pay.
Sir, I restore it.
Yes, sir.
And the CRLMC will be listed immediately because it is
Yes,
this
sir.
roster.
Yes, sir.
I'll see if there is nothing on the merit, I'll vacate the stay.
Yes.
I'll restore it and list it shortly. Huh? List it shortly. Right out. The CRLMC number 504 of 2022. Where is that order of dismissal?
Not been annexed.
Has been dismissed for non-prosecution on 23/6/2023. Mr. Sarmal and counsel for the petitioner fairly submits that the listing of the CRLMC escape notice of the counsel who was appearing. However, the application for restoration has been filed after the delay of about 500 days. He further submits that this is an inadvertent error in the office of the counsel appearing for the petitioner. Regarding head to the submission made by Mr. Sharma, I am inclined to allow the application for condemnation of delay subject to the petitioner paying 20,000 rupees to 50 said 20. I came down to 20,000 to the bar association. You give now election is going on. You pay the 20,000 rupees to the High Court Bar Association. By the delay of so and so is condoned. The CRLMC number 504 of 2022 is restored to its original file. Lease the CRLMC for hearing before assigned bench on the first week of April. First week of April. Huh? What first week of April? Okay.
47.
May I please yours? This is a application for modification. Here, your lordship on 3/3/2025, while restoring my allowing my application.
Modification of which order?
Modification of the order dated 3/3/2025 passed in.
What modification?
But here, your lordship will find first cause title. There were 3 petitioners originally at the time of the filing. Subsequently, after the criminal amnesty case was dismissed for default for non-prosecution, thereafter 2 of them they filed application under 438 and they on the direction of the court, this honorable court, they surrender and move for bail and subsequently they have been granted bail. So they themselves withdrew from the challenge in the present case. Only remain is Chittaranjan Raut petitioner number 3. I filed the restoration application at the instance of Chittaranjan Raut. Your lordship allowed that application. On that date also this order was passed that I will take the recourse available for being under CRPC. The problem is petitioners, the word petitioners have been mentioned, and usually your lordship, whenever your lordship is passing the order to take the recourse available under CRPC, your lordship is usually passing the order that issuance of non-bailable warrant is set aside. That much I want. I will take the recourse available under CRPC because of the fact that I was never been shown as absconder.
Where is the NBW order?
NBW order is Annexure 1 of the.
No, but 82-83 proceeding has already been initiated.
Subsequent to non.
Therefore, I have said that you go and surrender and move an application.
So that the problem arise would be I will not request pray before your lordship to deal with anything which has been happened subsequent to issuance of NBW. I am only concerned with the issuance of NBW because 82-83 process.
Consequential proceeding.
Yes, your lordship.
And this original proceeding, original challenge was there in 781.
The petitioner is seeking modification of the order dated 3/3/2025. 2025 on the ground that although this court has directed the petitioner to appear or surrender before the court on or before 25/3/2025. However, the NBW issued against the petitioner, execution of NBW issued against the petitioner by the order dated 28/11/2017 has not been stayed. Therefore, he seeks modification of the order. Regarding it to the submission made by Mr. Mahapatra at the bar, the petitioner is allowed to surrender before appear before the court below on or before 10th of April 2025. Till then, the NBW issued against the petitioner by the order dated by the Special Judge CJM CBI Bhubaneswar by the order dated 28/11/2017 in SPE number 9 of 2024 shall remain state. Yes.
Your Honor, the petitioner Chittaranjan Raut.
Petitioner
Chittaranjan Raut.
let it be for all. How does it make difference?
Two others, they have taken the remedy, able the remedy.
But then it's not that. Then not that. Why should I? If they don't want to avail, it's all right. It's already. Yes.
48.
May I please, Lordship? You can file an application by the occupant of 2 for recall of the order that is 6/3/2024, my lord. What happened, my lord?
6/2/2024,
my lord.
Yes.
The case on the second 376 and 313 was squashed, my lord.
Where is that order, sir?
Pardon, my lord?
Where is that order? 6/3.
6/3/2024, my lord.
Where is that order?
That is in I, my lord. 3030.
Yes.
2025, my lord.
Where is that order? Where is that order?
Page 8, my lord.
Page 8.
Yes, my lord.
3030.
Yes, my lord.
There is no order.
Clearance, my lord. 6/3/25, my lord. In clearance 20320 2024, my lord.
Where is that order? Show me that order. Don't give like this. Part of the record you have to put it.
Disposable.
Huh?
That is disposable clearance case, my lord.
You have to place that in the IA also. You have not placed that. At least you place it on record because see, all these are paperless courts. Adjournment counsel for the petitioner seeks to bring on record certain additional documents and seek an adjournment. 1 week time is granted to bring on record the release the matter. Bring on all these things.
Yes,
Yes.
49 and for the petition, file the petition of vacation of stay, but because the copy was not served.
You have filed it.
I'm the for the petitioner. Opposite party has filed a vacation of stay, but the copy has not been served. Lordship may take up any day.
Right. The opposite party number 2. Opposite party number 2 has moved an application for vacation of stay order. Vacation of the interim order passed on 19/3/2024. Copy of which has not been served on Mr. Mishra. Release the matter charge sheet. Yes.
50.
Interim order to continue.
Interim order to continue.
Oh, please.
50 extension of surrender time, my lord. Extension of surrender date, my lord.
50. 50.
Okay.
For the reasons stated in the application, the time for surrender ended up to 10th of April. It's made clear that no further extension shall be granted. Yes.
51.
51. Yes.
Opposite party number 1. Lordship, I'm
Are you appearing, sir?
1 week time. 1 week time, short adjournment.
You should have told the senior counsel. Just no informed. Well, he has been waiting there for.
Seven.
On the request of opposite party. Mr.
So pin number 2 is not appearing, in fact.
One.
No, C is appearing for 1. 2 is not appearing. The Vakalatnama is not filed. We can proceed with that actually.
We can proceed.
Right.
Service is complete. Why should you wait? Mr. S.P. Mishra along with so and so appear for the petition. Okay? Yes. I'll just run through. One through.
52.
Yes. Yes, sir.
This is a case minus 482 for passing of the offense under 138 NI Act.
You are accused.
I am accused. Here the accused number 1 is the main accused. Who has entered into agreement with the complainant. There is a rent agreement, which was not paid, for which he issued a check, and that was given. But accused number 9 is another company, and 7 and 8 who has issued the check, they are not a company who has signed with the agreement. Check issued by another company. What is accused number 1?
There are how many accused? 12 accused.
12 accused. I am for 10. He was a director. And man, that is
Sir, you are for 12. Accused number 12.
No.
Deepak Jha.
10.
You are for
Soman Chaudhary.
Soman Chaudhary.
Yes.
You are one of the directors of Center for Vocational
Yes.
and Entrepreneurship Studies.
Yes.
IIPM.
I am reading the complaint. Page 70. In 70.
Yes, who is appearing? You are appearing.
I am appealing for the opposite party.
How many people you are going to prosecute for 138 NI?
My lord,
You made 12 accused.
Your Lordship kindly look at the cognizance order, Your Lordship. Only cognizance was taken against 6 persons. Out of the
Against 10 it is not taken. Not taken.
1 to 6 was not taken. Who is the main accused?
It's all right, but if it is not taken against you, why are you bothered about it?
No, I am not bothered.
But because the check was issued by the
7 and 8.
9.
Let us see. The petitioner is Soman Chaudhary, Sandeep Ghosh.
Yes.
Sandeep Ghosh. Against these 2 persons, whether cognizance is taken?
Yes, Your Lordship. Against these 2 persons, cognizance was taken.
You said no.
My lord, here the petitioner, the accused number 7 and 8. Against them, the cognizance was taken. My lord.
7 and 8.
7 and 8. Accused number 7 and 8.
No, he is the accused number 10.
7 to 12. 7 to 12.
Let us see the cognizance order.
Yes.
Let us see.
Item page 54. I think.
Yes. Be sure, who are you? Accused number?
I am accused number 10. Soman Chaudhary.
10 and?
10.
10 and? There are 2 accused.
Yes.
10 and?
7, 8, 10.
There are 2 accused. There are 2 petitioners. Here.
1 Soman Chaudhary.
And?
Case that is criminal mischief 3478 of 1960.
Sir, you have filed a petition 1451 of 2017, isn't it?
I am for only 10.
Soman Chaudhary, and second petitioner is Sandeep Ghosh.
Sandeep Ghosh. There is same complaint. 4 cases. 4 cases, sir.
4 checks were dishonored.
First of all, first petition is 1451 of 2017. Take it out. 1451.
Yes. No, first case was D478 of 16.
Which matter you are arguing? There are
3478.
Okay. Shall I refer to 3478? Shall I refer to that petition or first petition?
First.
You must tell that first. Which petition you want? 3477 I will refer.
3478.
3478. That is the third matter. What about the first matter? Who is arguing for first matter?
First was same thing.
Not same thing. You have not seen it.
Accused same, but
There are 2 accused there, 2 petitioners there. There are two petitioners, just check it up. Here also two petitioners. Huh? Here,
Someone Chaudhary. 145 someone Chaudhary.
and second petitioner?
Sandeep Ghosh.
What yes is just see.
Yes, Sandeep, sorry.
Then
I'm sorry. Yes, sir. 3478.
and 3478 there are 11 petitioners.
Yeah.
There are 11 petitioners. Huh?
No.
How many petitioners?
Two.
Two petitioners again.
This
Sandeep Ghosh. Who is
Sure.
Sandeep Ghosh?
Yes.
Accused number?
Accused number 10.
Sandeep Ghosh is accused number 8, my lord.
8.
Then insofar as the 10 is concerned, no cognizance is taken against you.
Yes, taken.
So why not? That's what he says.
Page 54.
You are not, none of you are sure about
My
what
lord,
you are.
yes, 50.
Yes,
Yes.
54.
Let me see myself. Let me see.
The operative portion is at page 57, my lord.
Yes.
Yes, later. I mean, permitted.
Married. The case record put up today for order, complaint petition and initiate the statement of complaint in shape of a paper along with the original document filed by the complaint from which it.
Then as sufficient material to proceed against the accused number 1 to 6. So the process
7 to 8, 7 to 12. 7 to cognition was taken. 7 to 12. So issue process against the 7 to 12. Complaint is directed to file the requisitive within 3 days. Put up on about 12 to 15 for appearance. There is no sufficient material to proceed against the accused 1 to 6.
So no process can be 1 to 6 is generated. No cognizance is taken. 1 to 6. 1 to 6.
I am reading the complaint to complaint. Page 6, 7, first page 70.
Then Sandeep goes.
Yes. Kindly see.
Then 7 to 12 cognizance is taken.
Yes.
7 to 12 cognizance is taken in so far as the second petitioner is concerned in all the matters.
Well,
There is no cause that has to be allowed because no cognizance is taken. Only the first accused, who is the first petitioner, who is accused number 10, against him the cognizance has been taken. Yes.
Against 8 also, the accused number 8, cognizance was taken, my lord. So
I know that.
My lord.
1 to 6, you leave 1 to 6, talk about the rest. 7 to 12.
7 to 12.
Yes. Yes.
Where page 70.
17.
relevant page 20.
Yes. Yes.
That I have a second para. The accused person claims themselves as a founder, director, and director planning and management private limited, having its registered office, that is accused number 1. Accused number 1. Narayana Bihar industrial area, so an agreement on so with the complainant that there is a post error, monthly rent tenancy basis whose premises for complaint for academic and educational institute or a corporate IIBM and any other business directly or indirectly related to the business of the accused person. The aforesaid agreement was executed by the accused number 4, who is also director of the accused number 1. Agreement was signed with director authorized signatory of the pertinent here. That it is pertinent to mention here that in the latter part of 2011, the accused person had defaulted any payment to the rent as per the agreement, so and so. And after a due discussion with the accused number 7 and 8, issued checks, so and so, amounted, so and so, drawn in IBA. The accused number 1 and 2 and 9 are the company, they are a separate company. Accused number 1 is the main accused, here is described as main. 2 is not described, 9 was not described, and company's other accused person are director, accused 2 is the secretary of accused number 9 company. They and are in charge and responsible for conduct business of the company at the level they are actively participated. So this is the accusation against the 7 to 12 month. Lekin first kind is the first para it was mentioned accused number 1 it is separate address everything. Then accused number 2 also separate company. There is no allegation against it. And accused number 9 is a company. There is no allegation against the accused number 9. But check issue by 780 was the accused number 9. The company, accused number 9. There is judgments of Bombay High Court. If a check issue, suppose liability against A, issue check another B without creating any document or agreement, that cannot be, the liability cannot be transferred in a criminal case. May I read it? Without creating any documents.
Yes, what do you say?
Well, the check was issued by the accused number 9 company.
What he says is it is not legally recoverable.
Well,
For the liability of the other company, set of companies have issued the check.
same person. That's why, my lord, that's why the cognizance was not taken against the 1 to 6, accused number 1 to 6.
How will you?
If that is so, then the cognizance has to be taken against.
Have you
accused
challenged
number
that
1 to
order? Have you challenged that order?
No.
Well, because the persons are same, my lord. The
Same
persons
the
are
whole. Where it is written?
Because the check.
Without
Have
writing,
Have you filed the counter? Have you filed the counter?
Yes. You also kindly have a glance on the check, my lord.
Yes. Where is that check?
Counter is not necessary. Only the whatever the
Where is the check?
Content in the complaint is
Hey, show me the check.
not a defense is not necessary to be considered. Whatever the counter is without any.
Wait, Mr. Pradhan, let him.
My lord, the
He
check
has
was
also
issued-
say.
Yes, the check was issued by the Center for Vocational and
Yes.
Entrepreneurship Studies. That is the accused number 9. The accused number 7 and 8 are directors of that company. The accused number 10, he is also the director. 11 and 12, they are secretaries and directors.
Is it a company, International Institute of Planning and Management? Is it a company or what is this? Yes.
The
problem with you is the company for which this check was issued, that no cognizance is taken against that company.
It was,
Where is that?
yes, the cognizance order itself. The company is
No, 1 to
9.
1 to 6.
Yes.
1 to 6.
6 to 12.
And who is the Center for Vocational Enterprises Studies?
Exactly. That is the person. That is the company which issued the check in my favor. That is the company which issued the check.
But
in my
the
favor.
agreement was not signed
Yes,
between
9.
them.
That is the
Agreement.
Agreement is something different. The liability is something different. Yes. Yes.
Check was issued by the 9.
Okay.
And
I
others
understood.
are the directors.
I understood. File your response, written submission. Pass it on.
Where
File your written submission. I understood. Yes.
written?
I understood. You file written submission, I will pass the order. Yes.
No, I will cite some judgments.
What judgment? These small issues. What?
No, it is necessary.
Show me the judgment. Yes.
And Supreme Court detail.
Which para?
I am reading para 12.
What is the proposition? You tell me.
Proposition there, if a check issue liability against A, check issue by B on behalf of
This
creating
judgment you are reading.
Yes, yes.
This judgment is only five paragraph. Where from you will get 12 paragraph? Para 12? Where is para 12?
Para 12, para 2.
Para 2.
Yes.
Okay.
The
Yes.
matter arises section 130 negotiable instrument. The respondent file a complaint before the action for rupees 10,000 issue sponsor date that the aforesaid check was dishonored and subsequently notice was contemplated under section 130 was served and self-delivery the petitioner after that.
Yes.
That land and counsel for the petitioner that in my Marwadi, Mr. Marwadi submits that complaint itself shows that the check in question was issued by the petitioner for the liability of the petitioner 2 and 3. It was necessary in this context to refer the relevant paragraph. My client states that Sri Krupa Network are the franchisee of my client under an agreement so and so, and you are brother of the Nigesh Sagar, the proprietor of the.
Yes, I got it. Next, any other judgment?
And my client is
Hard copy.
under this
Hard copy.
para three.
Hard copy. I read it, para 3.
Para 3.
I read para 3 also. By the time you read 2, I read 3.
Oh, sorry. I am very Then para 4 then.
I'll read it.
In view of
The total judgment is 5 paragraph.
Yes.
I read it. Don't worry about it. I'll take any Supreme Court judgment you wanted to cite. Show me. Give me the judgment. No. Yes.
No, only para.
Give me the judgment and tell me which paragraph.
Oh, this is my copy. I agree.
It's all right. Your copy is good.
No, I mark the para.
That's far better. Yes. Which paragraph?
Para. I think I mark.
No, you have not marked it. Yes. Which paragraph?
I mark. I think. Oh, vocational. You are in what manner you are involved in this case?
In the complaint, it is said that you are responsible for the day-to-day affairs of the company, and that is what the complaint developed.
In what manner you have to
I know.
Another judgment, just in production of the.
You please highlight those things and give. I'll deal it with it. Yes.
Because just the production,
Yes.
whatever is contained in the statute, you just put on the.
I understand.
That is not sufficient. You have to
Just highlight those paragraph and give it. Give it. Yes. Next.
Oh,
Judgment.
maybe one.
Send it. Yes.
My lord, the
You
name
file
of the
written submission.
The name of the council is written wrongly, my lord, for the opposite party.
Now I am going to dispose of the matter. What to counsel? You
I have to give.
write your name and give so that in the
I have to give.
final order also. If you want to give, no problem. Better you give it.
Oblige.
Better you. Yes, next.
Oblige, my lord.
3 weeks I can give.
What 3 weeks is small matter?
No,
I can dictate right now because it is in length, therefore I am not doing it. Give it within 1 week.
No,
Okay, I'll wait.
2 weeks.
Okay, 2 weeks. Mr. Pradhan, Lieutenant Senior Counsel, 2 weeks time to file the written note of submission. Let him do so within 2 weeks. Please the judgment reserve. Yes, next. The one matter I kept it for. Can you please wait? I have fixed it to 30 years. 37. Yes.
Mr. Sarthak Nayak kept me waiting and welcome him on the board also.
Whether anybody is there?
Mr. Nayak's junior is here and Mr. Nayak is there on in VC.
Yes.
Your Lordship, Mr. Nayak had joined the meeting.
Yes.
He's here.
My lord,
Mr. Nayak, you being the special counsel, your appearance is also very special. You kept on waiting,
No, it's a pleasure waiting in this court. It's a pleasure, and it's pleasure to see Mr. Nayak also on the VC.
Yes, yes.
My lord, actually, on the last day, quite a few number of days, I made submission through VC. Now I thought that it would be better for me.
What is the matter? Is it
My lord,
very contingent?
15 lakhs of rupees was taken from the office of this accused person who has been already charge sheeted. He was a consultant in the particular company as a professional. He was neither in the board of directors, nothing.
What do you want to release?
Well, release that money, and your lordship also ventilated quite a few times. We also discussed the matter.
Yes, Mr. Naik. Let him keep some.
Lordship, the argument which he is making.
One surety. Forget about the technical discussion. Why to keep that money? Let him use and.
Lordship, what is the problem? Lordship, give me 2 minutes time only.
Yes.
So here the money is only 15 lakh rupees, your lordships.
15 lakhs, 15.
15 lakhs.
Yes.
Your lordships, if this order will be passed, suppose if in some accused house 100 crore is lordship seized.
And he will tell that you give me 100 crore rupees, 150 crore rupees. From Lalit Modi's house, Vijay Malia's house, a lot of cash was seized, your lordships. The law, your lordship, is not that it has to be returned back to the accused. Your lordship may read the judgments. The law says that it is the discretion of the court. It can be given to 4 people, your lordships.
Technically, I'm with you. You are absolutely correct. But it is a small amount.
But your lordships,
Release of that, the petitioner might have spent 5 lakh rupees by now.
but this, your lordship, this small amount, your lordships, belongs to the taxpayers' money. It is the money of your lordship chit fund investors who are poor.
What
Now,
condition you need, you tell me so that I can put
No, your lordship, I read the judgments which he has cited.
Yes.
The 3 judgments he has cited, your lordship, may pass any order. Let me argue the matter, your lordship, for a moment. The
Yes.
first judgment which my learned senior has cited is Sundar Bhai Ambalal Desai versus respondent.
Yes.
Now, your lordships, para 11 speaks about valuable articles and currency notes. How this should be dealt by the court, your lordships.
Yes.
Lordship, the primary objective was that it should not be written by the police officers and the court because it is subjected to natural decay and it has to be disposed of.
Yes.
But your lordships, in para 14, it says that in case such articles are not handed over either to the complainant or to the person from whose those articles are seized or to its claimant, then the court may direct that such articles be kept in bank lockers. So it can be given to the claimant, your lordships, and it has to be given to the complainant. Here the complainant is the chit fund investors, your lordships. And if your lordships will read the charge sheet, in charge sheet it is clearly and categorically mentioned, your lordships, that around 4.5 crore rupees he has misappropriated. Total scam, your lordships, is of 500 crores.
Yes.
Now the magistrate may, not must or shall, the magistrate may exercise his power to return any stolen property pending trial or investigation back to the complainant, your lordships. The language is to the complainant, not to the accused. Further, the magistrate...
Here the problem is there are many complainants. Whose money is that? To whom it?
Then it has to be kept in the bank locker. There is an alternative solution and we have already kept in bank locker, your lordships, in the Malkhana. In the name of CBI, it is already kept in safe custody.
Why can't it put to use?
Your lordships,
Why money is blocked?
Your lordship, suppose this money would have been your lordship's X amount. Now he will give that money in interest.
He'll give bank guarantee.
The lordship, it should not, the law is that it should not be returned back to him. Let it be kept in bank custody, your lordships. Your lordship may read all the judgments which he has cited. All the 3 judgments, and Supreme Court prima facie is of the finding that your lordship may kindly read. Your lordship was asking for Subrat Chhattora's judgment.
Yes.
In Subrat Chhattora's judgment, para 31, your lordships.
Para 31.
Yes.
Yes.
It is clearly written that, your lordship, the question is whether the above fixture called transfer of the ongoing to CBI or not. The court is saying in this paragraph, your lordships, the purport of the paragraph.
1 minute. Yeah, 31. 11. 31.
Last 4-5 lines, your lordships.
Yes.
While
Yes.
we do not consider it to need to go to the question whether the state police has done at all to have been done, we need to point out that money trail has not yet been traced. The collection made from the public far exceeds the visible investment that the investigating agency have till now identified. So also the larger conspiracy angle, Odisha and Bengal, although under investigation, has not been headway because of the interstate ramification which the investigating agency needs to examine. That means, your lordship, the Supreme Court is saying that you look into the money trail part. The Supreme Court is prima facie of the view that it is from the proceeds of the crime.
Yes.
And your lordship, this discretion which is the magistrate is going to exercise, this discretion, your lordship, flows from the Supreme Court judgment and the charge sheet. And if your lordships will read the trial court order also, in the trial court order, it is written that he told that he has made a statement that I am mentally unstable. So the person who is mentally unstable, his affidavit should not be accepted by this court, your lordships. Lordship, may kindly read the trial court submissions which he has made.
Where is that?
Your lordships, the trial court order, if your lordships will see, which he has annexed.
Annexure 1.
Annexure case 23 to 29, your lordships.
29. Yes.
Last night I was reading it, your lordships.
Yes.
Your lordships, he has made a submission, your lordships may read in the trial court. If your lordships will permit me, I would like to read that paragraph. He's
Yes.
He has given an explanation, your lordships, that the money belongs to the widow mother which he was accumulating, and other 2 amounts he has taken from relatives, but no documents were given. He further submitted that after the release of the petitioner from jail, he was quite unstable physically and mentally. So he himself has made a statement that he is mentally unstable. Then how the affidavit of a mentally unstable person be accepted, your lordships, by this honorable court? There is no averment made that when he became stable. केबे ठीक है किस लेखिनी. So if he's mentally unstable, he's acceptable. Your lordship.
Once he completes, then
Yes.
So
And
the affidavit of a mentally unstable person should not be accepted.
Milord,
will you give bank guarantee?
Milord, as your lordship, Milord directs. Milord,
I have not completed.
This can't be a precedent. See, whatever Mr. Naik said is correct.
Wait.
Because it is a matter of Ponzi scam.
No.
And the money which you have been seen.
Milord, kindly,
someone-
kindly, Mr. Naik, complete it because he will not
See,
let
this
me
is a
submit.
small matter. I cannot
Milord, he will not allow me to submit. Now see this.
No, I have not completed. Then you submit. Na? Let me complete.
He'll never
Delhi High Court
complete.
judgment. You. Aji to achandi pura submit kar diye. Delhi High Court has taken the view that your lordships, any seized currency notes to any person who is lawfully entitled to the currency notes. Your lordship, here lawful entitlement is of the investors, not of the accused. The rickshaw wala, kushtarogi.
I know. That's I understand it. The Ponzi scam.
Downtrodden section of the society. Supreme Court is saying that you investigate the matter. Supreme Court has also directed the ED to take up the matter, your lordships. By this time, ED should have seized that money, your lordships.
Yes.
In other chit fund cases, also in Odisha, your lordships will see the cases where CBI is taken up. The money seized. The
What is the denominations?
Milord?
Denominations.
Milord, new denominations.
2000 denominations.
Yes, Milord.
2000 or what? 500.
Milord, maybe 500 denominations.
You
That
tell
is
me
written
what
in
are
the, it is written in this.
That's very relevant question.
No, not the old one, the new one. All new.
Mr. Naik, denomination?
And your lordship,
500 rupees note.
2000.
Your lordship, we have already kept it in the Malkhana.
No, it's 500 rupees denomination, Milord.
Where have you said that?
Milord, in the seizure list.
Show me. If it's 2000 denomination, I am not going to do anything.
Never. No, I stand against that. Milord, I stand against that.
Huh?
I stand against that. If it is 2000 denomination, no.
Just see.
Your lordship will not allow me. Milord kindly takes it from me. It's an officer of the court submitting. Milord takes it. It is a new denomination.
Your lordship, tomorrow everybody will come. Tomorrow.
No, Milord, he will not allow me to submit.
Okay. It's all right.
Yes, please allow me.
Let me complete 2 minutes. I have not completed. How will I allow? Let me complete.
Let him complete. Yes.
5 minutes. The currency note seized by the police may be released to the person who is, in the opinion of the court, is lawfully entitled to the claim, your lordships. So, in the opinion of the magistrate, your lordships, the accused is not lawfully entitled. The lawful entitlement belongs to the persons whose hard-earned money they have duped, your lordship. Number one. Number two, your lordships, when the amount is more, people can always refer to this and ask for your lordships 25 crores, 50 crores, 100 crores. Here the amount is less, your lordships, only 15 lakh rupees. But this order can act as a precedent for the people, those who have duped your lordships 100, 200 crores and tell that give me. And that money they can put in interest. Suppose your lordship, the trial goes for 10, 15 years. In the interregnum period, your lordships, it should not happen. Something happens to the accused. Then that money is gone, your lordships.
Yes.
We cannot get that money back.
All right, I understood. This is the long and short of the.
Milord kindly takes up page 30.
Legally, you are not entitled.
Milord,
Otherwise,
31.
otherwise you
Kindly give this to lordship. Lordship 500 rupees notes. Kindly.
I take it. I take
Milord,
it.
being an officer of the
You
court,
simply tell me, can you give bank guarantee or not?
Milord, your lordship directs whatever. It is up to your lordship, Milord. I would only submit two things.
Yes.
As far as instability of mind was stated by him.
I am not taking it seriously.
Yes.
Okay.
Milord, because anybody taken into custody, an innocent person or any person after 1 year of incarceration, he would not be stable while coming out.
In some other case, I would have straight away allowed your application.
Yes.
But this is the case relating to Ponzi scam.
Milord,
so therefore, the money belongs to downtrodden.
Milord, I beg to differ on this with Mr. Nayak. Milord, the presumption of innocence, what he says, ED has not taken up this matter. Therefore, ED will not apply here. The presumption of innocence is in favor of the accused person. Filing of a charge sheet.
You answer me whether you want to give bank guarantee.
Milord, I leave it to your lordship for passing the necessary orders. Milord, kindly sees.
You give bank guarantee and take it.
Milord was of the view that 50% bank guarantee and 50% was the property guarantee, as your lordship on the last day has stated. Your lordship will kindly see, your lordship has already stated. I leave it entirely to your lordship, Milord.
I'll pass the order.
Your lordship passes.
Denominations are 500.
It is not 2012 what he is saying.
No, I have not said that.
Color photographs.
Yes, color photographs, whatever photographs, it is up to the investigating agency, Milord.
Yes. And bank guarantee. Okay. Yes. I'll pass the order.
And he shall give indemnity also if he is found.
Indemnity is common. Indemnity has to be given. That's not
I
a
say,
point.
because my lord, indemnity also he will give.
You indemnity you have to give. Over
Yes,
and above that, what guarantee? Because see, this is a Ponzi scam. It is whether it is your money or not. Ultimately, it is contingent upon the outcome of the trial. That's a different story. And but this money genuinely go to the people.
My lord, till now, how do I stand? I'm asking this to myself. I'm an innocent person, my lord. Per se, filing of a charge sheet does not make me guilty.
Technically, you may be correct. Technically, he is also correct.
No, my lord, I am not disputing. I am, my lord, accepting all this.
Yeah.
At the same time, had I been an investment maker over there, I would have felt the same pain.
Yeah.
I am not against him, but my lord, kindly consider if an accused person is an innocent and he suffers for the accusation only as a guilty, that is perhaps not, my lord,
but that will not be
permissible.
I will make it clear that it will not be a precedent for other matters. Yes.
Yes, my lord, and kindly allow, as your lordship has stated on the earlier objection.
I'll pass the order.
And your lordship, it was a privilege to argue against my learned senior lordships. You must come.
And it was my privilege, Mr. Nayak, also.
Thank you.
54. So your court adjourns verdict?
Why adjourn? Yes, I'll reserve the judgment, and if you want to place on record anything, then very
Deeply obliged.
A small written note, your lordship, I'll file also.
if you want to give, definitely. He has given. If you want to give Mr. Naik, you give
Your
it.
lordship, I'll give.
Okay. Yes.
May I please, so I don't know 54.
Without knowledge of the, I am for the petitioner.
Mr. Malana is not there, therefore. Yes, 54.
Short date.
54. Yeah.
Your lordship, I am for the petition in this case. The mediation proceeding is going on.
54.
Yes, your lordship.
When the date is fixed?
The date is fixed to 28/3/25. And there is every chance.
Mediation process in the present case is still going on. Leave the matter after 2 weeks.
On second week of April.
Huh?
Second week of April.
Third week of April. Yes.
Published.
457, 380. Bulky.
55.
55.
In the last date, actually, send it for mediation, actually. The report has
What report has come?
It's there in the list.
Mediation failed.
It failed actually, but my lord, actually, there was an earlier settlement between the parties. That
Then you are you still sticking to the earlier settlement?
earlier settlement. Actually, I have not talked. Actually, I today came to know that there was an earlier settlement. If the earlier settlement, actually, I shall have to take reference to it.
Then I'll just mediation is failed. Stated to be failed.
There was an earlier settlement that was in 2023. October 23, he has to pay some money and I have to vacate that place. That was the...
Okay. The matter was referred to mediation. Where? District Mediation Center?
This is Rourkela, Panpost.
District Mediation Center. The mediation report dated 17/1/2025 placed by the District Mediation Center, Rourkela. Rourkela indicates that the mediation is unsuccessful. Then account for the Mr. Pradhan, then account for the petitioner submits that there was an earlier statement, earlier settlement in the matter. He seeks an adjournment to get appropriate instruction in the matter. Accordingly, leaves the matter certain such date and the interim order continue.
Actually, the earlier, if it is on the record, then there is no issue. There is earlier settlement, I have to give it.
You have to place it on record.
I have to place it on record. Because on that day when it was discussed that whether we shall comply with the earlier settlement or not. That was both.
In the mediation, you should have said that there is an earlier settlement. Both of us bound to comply that. Let us see in that next date. The other side also will come. Okay, interim order to continue. Yes, interim order.
26th of this month, March 26th, if possible.
27th.
No, 26th. 26th of March, if possible, please.
But you have to come and tell me that, that's all. If you are going by the earlier statement, settlement or not?
Yes, that I shall talk with.
Yes.
That I shall talk with.
Yes. Yes.
May I please, Your Lordship? This is a case, my lord. In morality, I have no case. In legality, I have a case. In both, no, this is a case under section Payment of Wages Act. Statutory bar to initiate a complaint case. For that reason, Your Lordship also directed me to settle the matter.
Yes.
Because in morality, I have no case.
Then you pay it. Try to be moralistic and pay.
Legality, I have a case. Because he has to initiate proceeding within 1 year.
Will you pay it or not?
For that
If
reason,
you pay it, then I'll.
For that reason, I am praying my associate also. I have instructed that to take time up. Your Lordship may kindly give 2 weeks or 3
If
weeks.
paying something, you take it.
Otherwise, you will lose in.
Your Lordship may kindly have an order dated 15/3/2024.
15/3?
2024.
I have to concede before Your Lordship.
15/3, yeah. Yes.
Your Lordship. Lordship had directed to take instruction on the same and to make a good payment of the same, my lord.
You see, I recorded. On that ground, I passed.
Almost a year, my lord, has been passed, my lord. Today is 13th.
For that reason, 2 weeks. Because I have already instructed.
May
But the problem is there is an interim order. Therefore, you keep on asking time on that ground.
2 weeks. Last chance, 2 weeks.
Right on.
Well, it's kindly,
15/3/2023, a specific.
Fairly considered before morality, I have no case. Legality, I have a case.
On the specific query put to the council, he has sought time for seeking instruction from his client to make good the payment of wages to the informant. On that ground, on that ground, the interim order passed earlier was continued.
20th February.
Thereafter, the matter has been adjourned to 26/9/2024 and 2/12/2024. 2/12/24, 11/12/2024, then 5/2/2025, and 5/25. And when the matter again listed today, Mr. Das seeks last opportunity to get instruction. Release the matter on 21st of this month to obtain instruction in pursuance to the order dated 15 so and so, and the interim order till then will continue. Till that date will continue. Yes.
May I pray, my lord, this may be the last chance, my lord.
That's what I said.
That has been. For that reason, and first instance I have submitted.
You
Morality,
pay.
I have no case.
I wish that you pay and come and tell me.
I'm for the opposite party. But 58, item 58, I am
Yes.
During the last occasion, the opposite party, they prayed for, they are giving a response.
The question of compromise is not arriving. Let it taken before mediation, Your Lordship. Let it be taken for.
What are the offences?
498.
Go for mediation.
Your Lordship.
The matter is arising out of a matrimonial discord. Both the party, the councils appearing for both the parties conjointly submit that the parties can explore the possibility of settlement through mediation process. Accordingly, where mediation, where shall I send?
They are from Bhadrak, Your Lordship.
Bhadrak. District.
I want to just point out a grave error in the affair. Milord, the alleged offence is in February 2024, where BNS was not enforced. But for a offence of alleged offence.
Don't argue. These are matrimonial dispute. Go and try and settle the dispute. If it doesn't happen, then we'll see. Bhadrak district court Bhadrak explore the possibility and yes.
Grateful.
Please the matter. Yes.
59. I'm for the petition. I pray for time, Your Lordship. On behalf of Hon'Ble Pradhan.
59 for petitioner.
Your Lordship.
On behalf of Mr. Pradhan. Time. Let me consider the petitioner. Right, adjournment is sought.
60.
May I please, Your Lordship?
For the petitioner, pray for 1 week time.
Sorry,
1 week time.
you are appearing for?
Petitioner.
You have taken interim order now, 1 week time. How many hearing you have taken place?
No, I'm not time. First,
Let counsel for the petitioner seeks 1 week time on the personal ground. Leaves the matter on Sunday, interim order to continue. It made clear that no further adjournment shall be granted. Third week, yes.
61.
Yes, Mr. Sadangi.
Last occasion, they are supposed to serve a copy of that written note, what they have filed. It's against rejection of a cancellation order they have come up. They are supposed to give a copy.
Last occasion, my learned friend prayed for 1 week time for filing of a counter.
No. I never prayed for time. Mr. H.S. Mishra was there. No. Means?
Mr. Debasis Sadangi, learned counsel, has entered appearance on behalf of the opposite party. He seeks 1 week time to file counter affidavit in this case.
After they serve the copy.
You serve the copy.
My lord.
Why unless it's wasting time? Save the copy.
My lord.
My lord, apart from the petition, they have filed a document note of argument. That was maybe missing in the order.
Appeared on.
It's all right, but Mr. Sadangi doesn't have the entire set. You give.
I prayed for time. Thereafter, another counsel is engaged. Instead of that counsel, he prayed for time to counter the order reflect.
See, this is the part of strategy. What can you do? See, cancellation update, this happens. You know, if you would have been that way, you would have done the same thing.
It's high time. It's Millard's high time. At least the day we joined the bar, we are not supposed to make false statements in a court. It may be missing. No, what he is hampering at, that part is missing. That he is supposed to serve me a copy of that written note. 1 week thereafter, I
don't waste time, give a copy and let him file the reply.
Already notice was
and
issued to
the
him.
person is inside. It's
Notice was issued to him.
I am inside.
In some other case.
Notice is sufficient. After notice, one counsel.
Will you supply a copy or not? You tell me. Otherwise, I'll ask the registry to give a copy. What to do?
Already copy has been sent.
Easy issue to waste 5 minutes.
I don't want to
give a copy. If he would have been outside, I can understand. He is in custody.
I have a petition copy, but they have filed a
Please give a copy.
I will file copy.
Please give it.
On the other hand, another supplementary affidavit has been filed before the Hon'Ble Court. I have clearly stated there.
That copy is supposed to give.
I will serve the copy.
What are you arguing? I am not hearing today. You give the copy, let him respond to that. I'll hear it. Please give it a copy. Why to waste time? Please give. I would have photocopy the problem.
I am not on the petition. Subsequently, they have filed.
I will serve the copy.
Is he not your friend? Otherwise, also privately can ask you.
I will serve the copy. It is delayed process.
I can understand if he would have been outside, I would have. He is in custody in some other matter. Even if it is cancelled, how does it make difference?
I will serve the copy.
I'll hear it. Right on.
But in the meantime, the IFC process may be directed to.
Counsel for the petitioner shall supply a copy of the petition.
Petition is there. Note of argument and other affidavits they have filed.
And the entire petition along with the annexure and the written note of argument to Mr. Sadangi. Mr. Sadangi should to respond to the same by next date of hearing without fail. Without fail, lease the matter on.
Today I am giving.
Give it, I am recording. See, he will accept it thereafter. He'll say that this was missing, that is missing. Why are you wasting time in? Yes. Lease the matter. Yes. Yes.
62.
My client is inside. At least I could take instruction and we 2 weeks.
Yes. Lease it. Yes. Yes.
In 62, my lord, I am appearing for the opposite party, my lord. Wrong, though I had mentioned both of the cases to be clubbed together, wrong number has been mentioned. That's why.
Because that number is related to vigilance case, and I think why
it should be 3470 of 2022.
62.
Yes. CRLM
3470
of 2022. But it was written 24.
20
Yes.
24 ହେଇଯାଇଛି
Yes.
ଆଜ୍ଞା
24 ହେଇଯାଇଛି 22 କରିକି
ଆପଣ
କର।
22 ବୋଧେ ଲେଖିଛନ୍ତି
ନା ନା ମୁଁ 24 ଟା ଦେଖିଲି vigilance case.
Pardon to mention, my lord, item 60.
Inadvertently, the CRLMC number 3470 of 2024 is tagged with this matter. Then counsel for the petitioner submits that in fact criminal MC number 3470 of 2022 is related connected with the present matter. Release the both the matters to yes.
Pardon to
order may be
Interim order to continue.
Pardon.
May I please? Last occasion on 6/2/25, my lord, your lordship directed the state council to obtain inspection.
My lordship, this is under section 498A, the notice to be issued to the wife, because I have received the CD, my lordship, the investigation on my lordship.
Now, what happened, my lord, arising out a complaint case, your lordship turn to page 16, my lord. Para 9. I am the accused number.
FIR is already registered.
Yes.
Yes, my lord. What happened, my lord? Allegation is that I am no way connected. I am spying the complainant. That's why I have been implicated. I am a diploma student, my lord.
I understand. That's the reason I issued notice.
Yes, my
But
lord.
investigation is still going on.
Yes, ma'am.
That's why your lordship.
He doesn't have any role. You fight it out. These people can fight it themselves. But why a third party is being?
Yes, my lordship, but investigation on and 161 statement I have received from the wife, and she implement all the people of the in-laws. So my lordship.
Including the petitioner.
Yes, yes. Every people name is there.
Charge sheet filed.
No, my lordship.
How much time will it take?
That my lordship has not there closed the diary and the pending further investigation of the case. It was written.
Mrs. Manana, counsel for the state submits that the investigation is still in progress, and the statement of witnesses under section 161 CRPC has been recorded.
The wife.
Complainant has been recorded.
Yes,
Complainant, she has implicated the present petitioner. She submits that the remaining evidence to be collected would decide the fate of the case of the present petitioner, and she seeks an adjournment to get a fresh instruction regarding the complicity of the present petitioner in this case. Please the matter on
Short date.
So that she can come if it can be.
If there is no complicity here, at least he will be out. Thereafter, they'll fight it out. That's what. Shall I issue notice?
Yes, my lordship.
Have you implemented? He is not implemented. That's the problem. That's the whole difficulty.
I am no way connected. I am a student, my lord.
all
For
right,
this reason, my lord.
Can I decide? Am I investigating officer?
No, let them file an counter.
On that ground, I can dismiss it. But see, try to appreciate. Now the FIR is registered. Investigation is going on. Keep on filing affidavit. I should not have entertained in the first instance this petition. I am doing it because the young man who has nothing to do with. Therefore, I am doing it.
Yes, yes.
I am giving that indulgence. Otherwise, it's not fair for the 482 court to entertain this kind of petition at all. I am doing it only because of you are not related to the family. But if she has implicated, what can I do? Charge sheet is bound to be followed. How file? I can't say that don't file, even if there is evidence.
Lordship,
can't do that.
Yes, yes. Let them
So
file.
therefore, at least this pressure would be there, then they may exonerate you. That is the whole idea of doing it.
Short date we have given.
He'll give it. Yes. How do we give it?
On 7/2/2023, my lordship directed London State Council to, while issuing notice, lordship directed the State Council to obtain instruction regarding the status of the investigation.
Not yet come.
Since
my lordship.
2021,
Not yet come. Today morning also I called that. Yes, but not yet come.
The Mrs. Marana, counsel for the state, submits that pursuant to the order dated 7/2/2025, she has not got the instruction, and she seeks an adjournment. Leaves the matter also to obtain instruction. Yes.
65.
My lords, I am appearing on VC matters. I'm sorry, my lords. Lordship, in these cases, lordship had directed the state to obtain the status report.
Yes, yes, my lordship. I received the instruction, my lordship. May I read that operative?
Lordship, if I can have a copy of that, son, Lordship, call it some other date.
My lord, in this case, I am appearing on behalf of the opposite party number 2. Complainant. In the meantime, they have filed the anticipatory bail application, and honorable court was pleased to dispose the application as per instruction.
Protecting them.
They have surrendered and protected by the law and court below.
I'm only asking. Yes,
That is a different thing.
Yes.
Persons
If the report is there.
Pursuant to the order dated 7/2/2025, which is Maharana has obtained instruction.
Yes.
She seeks 1 week time to place it on record by supplying the copy to the other side. Lease the matter on such. Yes.
Deep level.
15 go to pass over. Item 19 pass.
It's over.
Yeah.
19, huh? Yes, sir. 19. What do you want?
This is when the petitioner seeks to challenge the order of cognizance passed to the learned court below on 2 grounds. Now, these lots of in this case, particularly one complaint is registered against the petitioner, alleging that in the year 1932 and 78 and 1982, the forefathers of the petitioner have caused a registered partnership deed. Allegation of 1932, 78 and 82. And thereafter, the police was directed to conduct an investigation. Police filed the final form saying that the allegations are false and frivolous.
Yes.
Thereafter, the protest petition was filed by the petitioner by the informant. And in the protest petition, the magistrate has taken the cognizance. So my ground of challenge is twofold. But the allegations are entirely civil in nature and has given a cloak of criminal offense. And secondly, since it's the cognizance order has been taken under section 191A, that is based on a private complaint. So the magistrate has to record reasons behind taking that order of cognizance. Those two things are absolutely absent.
Where is the cognizance
order? Yes, page number 42. I'll just show the page 42.
Yes.
Order dated
42
28 of May 2023.
May
28th of May 2023, page 42.
42. Yes.
The learned counsel for the complainant is present.
Yes, madam.
My worship, the file is not with us.
See what he says, the second point is very important. He says that since the cognizance is taken on the protest petition, reason has to be there. There is no reason at all.
Private complaint.
Private complaint.
I will take the instruction.
Reason has to be said. Petitioner is agreed by the order dated 25/2023 passed by JMFC 4 Bhubaneswar, whereby cognizance of offence punishable under section 420 of the 34 IPC has been taken against the petitioner. And counsel for the petitioner submits that initially the FIR was registered against the petitioner being Bodogoda, PS case number 79 of 2016. After investigation, a closure report has been filed in the present case on 30th April 2021. Inter alia, arriving at a file. The IO has arrived at a finding that these are the allegations are emanating from a civil dispute. The opposite party number 2 has filed a protest petition. On the protest petition, now the cognizance has been taken by the impugn order. And counsel for the petitioner submits that since the cognizance is taken, then counsel for the petitioner apart from arguing the case on merits, he has pointed out that since the cognizance has been taken on the protest petition, and it is obligatory on the part of the magistrate to assign reason while taking cognizance. However, the impugn order is devoid of any reason. Issue notice to opposite party number 2, written on so and so. In the meantime, proceeding before so and so is taken. Okay.